Welcome back to the Constitutional Clarion. This video is about the difficult issue of how Parliament can deal with politicians who are alleged to have committed serious wrongdoing or who have been found by a court or an inquiry to have done so. While an ordinary employee might be suspended or sacked in such circumstances, it's much more difficult dealing with politicians in these circumstances. Why, you might ask? Well, first, because politicians are elected by the people rather than being employed. Second, because parliamentary privilege protects them to some extent so that they can fulfil their parliamentary functions. This includes giving them freedom of speech in Parliament, for which they cannot be held to account in any court, even though the content of the speech might be reprehensible and a breach of the law, or indeed a code of conduct. Many years ago, I ran the legal branch of the New South Wales Cabinet Office, and I had a shelf in my filing cabinet which was dedicated to allegations of misbehaviour by ministers. Now, my role was to advise on whether they had triggered a constitutional disqualification or breached the ministerial code. I also had to advise on expulsion or the suspension of members, often after adverse findings had been made by the Independent Commission Against Corruption. These days, in the Me Too era, it's issues about bullying and sexual harassment that are at the forefront of disciplinary concerns. I'm going to deal with those in a separate video on the proposed Independent Parliamentary Standards Commission, so watch out for that one, should be coming next. If a politician is convicted of a crime, the position is relatively straightforward. At the Commonwealth level, Section 44(2) of the Constitution says that any person who has been, quote, convicted and is under sentence or subject to be sentenced for any offence punishable under the law of the Commonwealth or of a state by imprisonment for 1 year or longer, unquote, is incapable of being chosen or sitting as a senator or member of the House of Representatives. First, it only applies while a person is under sentence or subject to be sentenced. Just because a person has been convicted and sentenced in the past does not disqualify them from Parliament once they have served their sentence. Secondly, the key criterion is whether the offence of which the person has been convicted is punishable by imprisonment for 1 year or longer. The actual sentence given in the particular case might be shorter than that. What's relevant, however, is the potential maximum sentence for that offence. But what can be done where a person has only been charged but not yet convicted of an offence, or if they are convicted but the offence is not such as to trigger disqualification? Their presence in Parliament might still be regarded as a source of risk to the welfare of others, or indeed as bringing Parliament into disrepute. Expulsion or suspension may be options depending upon the jurisdiction. Section 8 of the Parliamentary Privileges Act 1987 from the Commonwealth removed the power of a House to expel a member. So expulsion from the Commonwealth Parliament is no longer possible. Back in 1920, a Labor member of the House of Representatives, Hugh Mahon, was expelled for a speech he gave at a public meeting in which he criticised British actions in relation to Ireland and urged that Australia become a republic. On the 11th of November, which of course, as we all know, is a dangerous date for political dismissals, the Australian Prime Minister, Billy Hughes, moved a motion to expel Mahon for what he described as seditious and disloyal utterances. He regarded Mahon as being guilty of conduct unfitting for him to remain a member of this House and inconsistent with the oath of allegiance that he had taken upon becoming a member. The opposition leader, Frank Tudor, argued that if allegations of sedition were to be made against Mahon, he should be tried before a court like anyone else. Tudor also pointed out that the allegations did not concern Mahon's conduct in the House or fall within its disciplinary jurisdiction. The motion, however, was passed on party lines and Mahon was expelled without there having been a parliamentary inquiry or even an opportunity for Mahon to defend himself. When a joint select committee was established in the 1980s to consider legislation about parliamentary privilege, it pointed to the example of Mahon's expulsion and it recommended that the power of each house to expel its members be removed. This was because A, the power can be politically abused, B, the Constitution already provides for disqualification in particular circumstances, including conviction for a crime and other matters like bankruptcy, and C, it's for the electors, the voters, not the members of Parliament to decide the composition of the houses. Parliament agreed with that analysis and legislation was enacted which included the ending of expulsion. Although the legislation could, of course, be amended and that power to expel be restored in the future, if the Parliament so desired. In contrast, in New South Wales, there is no statutory or constitutional source for the powers of the Houses. Instead, reliance is placed upon the inherent powers of the Houses based upon the concept of reasonable necessity. In New South Wales, therefore, a member can be expelled by a House if this is reasonably necessary for the proper exercise of the House's functions and its self-preservation, including the protection of the, quote, high standing of Parliament, unquote, so it may discharge its functions with the confidence of the community. But expulsion may not be used in New South Wales for the purposes of punishment. Expulsion, however, is an extreme measure and it does raise a tension with the constitutional principle of representative democracy. It effectively overturns the choice of the people, but it may also be necessary for the maintenance of public confidence in the House. If expulsion results in a by-election, this may in fact enhance representative democracy by giving voters the opportunity to make an informed choice as to whether to retain a person as their member if he or she chooses to stand for the by-election after they're expelled. But this is not always the case, as the Tasmanian House of Assembly, for example, uses recounts to fill vacancies, and upper houses, in which the entire state is an electorate, tend to appoint another person to fulfil a casual vacancy as nominated by the relevant party. This denies the expelled member the chance to appeal to the people. From a democratic point of view, suspension of a member for a significant period is actually more problematic than expulsion because it denies the electorate the effective services of a member during the time of suspension. Lord Selborne from the Privy Council noted in the case of Barton and Taylor in 1886 that the rights of constituents must be kept in mind, as those rights would be much more seriously interfered with by an unnecessarily prolonged suspension than by expulsion, after which a new election would immediately be held. While the source of power to suspend may, in the various different jurisdictions, be found either in the Constitution or in statute or in standing orders of the Houses or even the inherent powers of the Houses, they all tend to be tied back to the power of a House to protect its functioning. A House of Parliament may discipline and suspend a member who disrupts proceedings or refuses to obey an order of the House. But it's less clear whether the House's powers extend to conduct that does not affect the functioning of the House other than the mere presence of a disreputable person in the House. This issue arose in New South Wales in 1906. William Criek, known as Paddy, was suspended from the Legislative Assembly after a Royal Commission made findings of bribery and corruption against him. As a criminal charge had been laid and the matter was sub judice, which means that it's before a court, so it shouldn't be discussed in Parliament, the Legislative Assembly made a new standing order that permitted a member to be suspended until the verdict of the jury is returned on a criminal charge that has been laid against a member. The New South Wales Supreme Court held in a case called Criek and Harnet that this standing order was invalid because it was not one that regulated the orderly conduct of the Legislative Assembly. According to the Chief Justice, the fact that a criminal charge is pending against a member, quote, in no way affects the course of business of the chamber, is not in itself an obstruction to such business, and in no way affects or has any relation to the orderly conduct of the House, unquote. He thought that the Constitution deals with criminal offences by way of disqualification, and that during the period prior to any conviction, the member must be presumed innocent. He saw such a suspension as ignoring that presumption of law and ignoring the rights of the member's constituents, who he saw as practically disenfranchised. On appeal to the Privy Council in Harnet and Criek, 1908, the Privy Council overturned that decision of the Supreme Court. Their lordships accepted that Mr. Criek's conduct may have been considered a deliberate insult and challenge to the whole House. The court treated the suspension as being one of self-defence of the House, which would therefore fall within its inherent powers rather than an exercise of punishment. In my view, the reasoning of the New South Wales Supreme Court is actually better. The Privy Council judgment seems to have been affected by its distaste for Criek's conduct, and there's more of that in the judgment than there actually is proper legal reasoning. But in any case, Criek's case concerned matters of corruption and dishonesty, so it's at least arguable that such conduct could affect public confidence in the proceedings of the House. It might be a different matter, however, if the alleged criminal offence, for example, was something like reckless driving. Criek was something of a character in colonial New South Wales and had also been expelled from the Legislative Assembly for unruly and violent behaviour after a Melbourne Cup drinking session in 1890. But his constituents obviously supported him because he was voted back into Parliament to fulfil the vacancy that was caused by his expulsion. Similarly, when Richard Price was expelled from the New South Wales Legislative Assembly in 1917 after making allegations against a minister that were found by a Royal Commission to have been made wantonly, recklessly and without any foundation whatsoever, he too was re-elected by his constituents. In more recent times, the member for Kiama, Gareth Ward, was suspended by the New South Wales Legislative Assembly after he was charged with historic sexual offences, which he denies. At the following election, his constituents, despite knowing of these charges and his previous suspension, still voted him back as a Member of Parliament. Given that democratic mandate, the House chose not to suspend him further pending his trial, which at the time of recording still has not yet taken place. The New South Wales Standing Committee on Parliamentary Privilege and Ethics, when considering the issue, expressed doubts as to the appropriateness of a majority of the Assembly acting to diminish the rights of the member's constituents to effective representation, particularly when the member has been re-elected when the public had full knowledge of the charges. The committee was concerned about provoking litigation about the issue and about the effect of any resulting delay in the criminal trial on the well-being of the alleged victims and witnesses. It was also concerned that suspension might undermine the presumption of innocence, and cause a temporary or permanent stay of the criminal trial. For all of those reasons, a further suspension was not pursued. When Ward was earlier suspended, contemplation was also given to whether he should have his salary reduced or forfeited during the period of suspension. But if such action were punitive, punishment, it would not fall within the House's inherent power. Ward continued to actively work for his constituents during his suspension, so there was difficulty in saying that his salary should be denied because he was no longer fulfilling his parliamentary functions. He was indeed still working. In 1947, in the case of the Crown against Dixon ex parte Barnes, the Queensland Supreme Court held that a House has no inherent power to deprive a suspended member of his or her salary during suspension. This was because a resolution suspending a member without pay was punitive in character. It had been argued that the denial of salary was intended to protect the House and fell within its self-defensive power because it operated as a deterrent to misconduct. This argument was rejected by the Chief Justice, who pointed out that fines and prison sentences are also intended to deter, but they're also clearly punitive. He thought that depriving a member of his or her salary was in the same category as the imposition of a monetary fine. One problem with suspending a member pending the resolution of criminal charges is that it may take a very long time. Ward was charged in March 2022 and suspended from Parliament until he was re-elected a year later in March 2023. And as of September 2024, when filming this, his trial still has not yet been held. If a member is convicted of an offence, there is then the issue of appeals to consider and the intersection with any constitutional provision concerning disqualification from Parliament. In New South Wales, for example, the state constitution was amended in June 2000 so that disqualification does not occur until the time for commencing an appeal has expired or any appeals that have been commenced have been determined. However, the option of expulsion or suspension was deliberately left open in the meantime. The same clarity does not apply at the Commonwealth level. There, the Houses may suspend their own members, but the Parliamentary Privileges Act does impose some limitations. For example, Section 4 provides that conduct does not constitute an offence against a House unless it amounts to an improper interference with the free exercise by a House, its committees or its members, of their authority or functions. Enid Campbell has argued that Section 4 restricts the punitive powers of the Commonwealth Houses of Parliament to suspend members. She also contended that the implied freedom of political communication drawn from the Commonwealth Constitution would now also affect the powers of the Houses to suspend a member, although it remains to be seen whether the High Court would take that view. There are two instances of members of the Commonwealth House of Representatives being suspended in the 1980s for criticism of the Speaker in one case or another member in the other case, with suspensions amounting to a few days in the absence of withdrawal or an apology. Both occurred, however, before the implied freedom of political communication was first recognised by the High Court in 1992, and the suspensions were not challenged in a court. On the whole, the suspension of a member who has been charged with a criminal offence is actually very rare. Ordinarily, members either resign from Parliament or continue to sit, but often as an independent, as their party will often expel or suspend their membership. There is traditionally also a bit of a charade where one side will say that the other should not accept the vote of the charged member, when of course no party has the power to accept or reject a vote, and it's up to the member to decide how to vote on any matter before the House. Well, that's the story about the disqualification, expulsion and suspension of MPs who have been convicted of offences, charged with offences, or otherwise found to have engaged in serious misbehaviour. Thank you for watching the Constitutional Clarion again, and as always, I look forward to seeing you again next time. Goodbye.